Hello, welcome friends. We are still in Unit 1 and we are going to move to the case now. So we've talked about how our law kind of came about and we talked about um, the laws we have, the Constitution, enacted law, common law. And we talked about the importance, the hierarchy, which one is the most important. So now we're going to talk about the case and we're going to talk about plugging in that law. So we got ourselves a law and we're going to talk about elements of the case. And then we're going to talk about two types of different ways you categorize law: substantive versus procedural, criminal versus civil. And then we're going to talk about elements in a case. So hold on, people. Fasten your seatbelts. The first thing that we want to talk about is elements of a case. So once you have your law, you are going to see a case or a claim. We call them claims. Always have component parts. And they're going to say, you need to prove this, this, and this. And if you don't prove it, the plaintiff, whether it's a civil or a criminal, then you don't win your case. And we're going to talk about the standards you have to prove it by. But I say, look at it like a recipe. Okay, I've got a recipe and I need to make cookies and I need eggs and I need flour and I need sugar and chocolate chips. If I don't have the chocolate chips, I don't have my chocolate chip cookies. Let's call them chocolate chip cookies, okay? If I don't have my flour, I don't have my chocolate chip cookies. The law will tell us what do we need to prove a claim, and those are called elements. So elements of a case are just the different components you need to prove. And so let's talk about classifications of law and how we can classify the law. One way is we talk about law as substantive or versus procedural law, okay? And all laws are either substantive or they're procedural. And what that means is substantive law says these are the rights and obligations, okay? Which mean, for example, a substantive law is in the Constitution, for example, is that we have to, like, the government is allowed to pass this statute. It tells the government what they can do, or it tells them us what we must do. For example, we must file our taxes. That's an obligation, that's a law. Other things include elements of a crime. That's substantive law. This is a crime. Or it would say, this is what it is to commit civil battery. That's the substance. That's the actual substance. It's going to have elements to it. Okay, it's going to tell us what we need to do. And it's rights, meaning we get this, or obligation. I'm obligated not to do something. I'm obligated not to speed. I'm obligated to pay my taxes. Okay, so it's going to be like a definition of a crime, a claim, a defense. It's just how I do that. Procedural law is the laws by which this law is created, applied, and enforced. Okay, so what that means is, for example, well, mostly in courts of law, we're talking about to prove your claim, you must prove beyond reasonable doubt. That's a procedure. To file a lawsuit, you must serve someone paperwork. You must give them notice. This is all procedures that we take: venue, notice, jurisdiction, objections. Objections are procedures of what we have to do for us to make an objection or, to object to something. What you want to think about is it tells me how to go about defending and enforcing these rights and obligations. So it tells me what I need to do to make a claim against someone. It tells the government what they need to do to prosecute. It tells me the procedures of which to defend myself. Substantive and procedural law. We'll work a little bit more with that as we move on. But I want you to realize procedure is a procedure, substance the substance. It tells us what something is, what a claim is, what a defense is, what a crime is, okay? So then we also have a classification of criminal or civil. And I want you to keep in mind these, like they're different file folders or boxes. I have a case and it's in a criminal box or it's in a civil box. And why is it important? Why do we classify them? because the substantive law and the procedural laws are different. I may want to sue you for battery, physical battery. That may have different elements, and that's substantive law, right? That may have different elements than a criminal battery that the state has to prove, okay? Procedural laws are different, extremely different. You might have you have a total different rules of evidence, and our rules of evidence are all procedural. It's how to present evidence and how evidence is handled. It's going to be different for civil versus criminal, okay? So we have these classifications of law, and how do we know the difference of which one's which? Well, it's the 3 P's. We have purpose, we have proof, and we have parties, or purpose, parties, proof. The first thing is, when we look at the criminal case, the purpose is to protect society, to punish, deter, to rehabilitate, maybe to give retribution to the victim, okay? In a civil case, it's to right a wrong. We're going to settle a dispute between 2 parties. We want to make the plaintiff whole. We want the person who's suing us to be able to become whole again after something's been done to them. Sometimes we want to force the respondent to do something. Get off my property. I want an injunction to get you off my property. And we sometimes punish for outrageous conduct. But civil, it's not meant to be punitive. We do it because someone's committed outrageous conduct that we need to send a message. In both cases, we're going to have parties. We're going to have a plaintiff, sometimes the petitioner, and they're the ones that file the action. They're the ones with a cause of action that they say, hey, wait a second, I am going to file something against you, the defendant. The defendant, sometimes called a respondent, is the one that is being filed against. I don't like saying defending because in criminal law, a defendant really does not have to defend themselves. The law says they're presumed innocent. So a defendant sometimes becomes a little hard to say defending themselves in that case. But these are the parties. We call them plaintiff, we call them defendant, but sometimes you may say petitioner or respondent, okay? So in a criminal case, it's always, always, always the government. The government is the only one that can file a criminal case against you. A civil party cannot. A person, business, entity may have input to what the federal not federal, it could be federal or state, what the government does, but they do not file charges. They don't get to press charges. So you see that a lot. Even the news media sometimes says press charges. It is always the government. You're going to see the state of Kansas, or you're going to see the U.S. District Court, or you're going to see, if it's a municipality, you're going to see the city of Olathe, the city of Overland Park. That is a criminal case, okay? In a civil case, it's going to be a person or entity. Sometimes it can be the government if they're filing a civil lawsuit to go after you for money damages, especially in business, okay? But if you see a government, okay, it could be a civil or criminal, but you will never, ever, ever see, again, a person, business, or entity filing a criminal case, okay? So that is the main difference, okay? And look for what they're doing. Are they going in the civil code or are they going in the criminal code? Now, the last thing is our proof. And we have a list of burdens of proof here, and I'm going to talk about those in relation to proving our case. But it's the legal standard that you have to provide to demonstrate your claim. A preponderance of the evidence is a civil case. Preponderance of the evidence. And what is that? More likely than not. Does it seem more likely that this plaintiff's case has the plaintiff has met all their claims? It's a different standard than in a criminal case. A criminal case is beyond a reasonable doubt. And so the highest level is in a criminal case, and that's because of our constitutional protections. We have that constitutional presumption of innocence. And so you must be guilty of every element beyond a reasonable doubt. So let's see how that works. Elements of a case, remember, are the component parts. So let's say I'm going to have elements of a civil fraud. What's civil? That means I'm suing you, you're suing me, someone's suing someone. And let's say the elements are false or untrue representation was made as a statement of existing and material fact, that it was known to be false or untrue by the party making it, or was recklessly made with knowledge concerning the representation, that it was intentionally made for the purpose of inducing another party to act upon it, the other person reasonably relied and acted upon the representation, and the other party sustained damages. That's all the things you have to prove for civil fraud. If you say someone's defrauded you, you have to prove this. Okay? Every what? Element. They're all elements. And what do I prove? In a civil case, it is more probably true than not. The plaintiff has to prove by more probably true than not. That's preponderance of the evidence. So what you say is, if you're the plaintiff and you're suing someone, you say, ladies and gentlemen, we have proved to you every claim more likely than not. What does that mean? Even a hair over 50% in favor of my case of every element wins this case. Okay? That means what? The defendant or the respondent is liable. Civil case is liable. Okay? Now, let's look at elements of a civil fraud. Oh, we did. I'm sorry. What this is saying is that everything then has to be by a preponderance of the evidence. What I just said, more true than not. Okay, let's look at criminal damage to property. Criminal now. Switch your brain to the criminal box. And to prove that, and the reason I didn't use fraud to compare it is this is where it's different substantively. Remember, substantive law is what the law is. Well, there is not in Kansas, and that's what I use the civil fraud for. In Kansas, they don't have just criminal fraud. It's all different types of fraud. Okay, so you would have to go to the particular one. So we're going to use criminal damage to property as an example. So the state, then the government, because we're in a criminal case, has to prove, right, that somebody, which would be the victim, had an interest in property. The defendant knowingly damaged, destroyed, defaced, or substantially impaired the use of by means other than by fire or explosive. And that the defendant did so without the consent of the victim. And the property damage was extent of, and then they have different levels. And the reason they have different levels, just as an aside, is when it comes to sentencing, depending on how much the value was, it's what level of crime. But they always also have to prove that the act occurred in the jurisdiction that they're at. That's always going to be in a criminal case. These are the 5 elements the government has to prove, okay? And what is that burden of proof? If you have a reasonable doubt as to the truth of any of the claims required to be proved by the state, you must find the defendant not guilty. If you have no reasonable doubt as to the truth of each of the claims required to prove by the state, you should find the defendant guilty. So they have to prove facts beyond, they have to apply their facts beyond reasonable doubt for every single element. And that's how you prove your claim. So what happens if somebody, and we're going to go to civil because this doesn't happen on the criminal end, but I'm going to give you this little insight because your next video is on briefing a case and you're going to come up with this thing called summary judgment. Okay, what is summary judgment? It applies to a civil case. And basically what that means is you have filed a lawsuit on someone and there are no disputes on the material facts. Both parties agree these are the material facts. Yet you have not provided anything for one of the elements of your claim. Okay? That's called failure to state a claim upon which relief may be granted. What that means is you don't have the evidence to prove this. So the other party can come to the judge and say, why would this go to trial? This is a waste of everybody's time. We agree. This is the evidence. They can't prove this one. Give me summary judgment. And the judge makes a judgment dismissing the claim. Okay? Now, this can also happen, summary judgment, if a defendant has a defense that cannot be refuted. The defense may say, oh, okay, I'm going to ask, this is the statute of limitations and it's expired. And we both agree on all these facts. And this is the law, judge. All you have to do is apply it and you'll see that we shouldn't even be here. The judge can issue summary judgment. And we're going to talk about this a little more when we talk about briefing a case, because a lot of cases in civil will end up before the court because the court has entered a summary judgment. And that is a judgment on a claim without a trial. They never had a trial. If you have multiple claims and that you get summary judgment on one of the claims, that'll still proceed to trial. But you can still appeal that claim that was issued summary judgment. So in a nutshell, that is what summary judgment is. So we have our elements, remember, that we have to prove by our standards of proof. And in a civil case only, you could get summary judgment. This does not apply to criminal case. This has a different procedure. But because we are going to be studying mostly civil cases, almost all your briefs, all of your briefs will be civil cases, it's important that you understand this concept. So what's next? Next, you need to go to the court, the case briefing, and it is in part of your assignments, and there'll be a video there to explain it, and it's part 1 of your case briefing, which will walk you through how to do your initial part.